Hello, my name is Christopher Badger, barrister at Six Pump Court, and welcome to the second edition of our Environmental Law News Bulletin, brought to you in association with LexisNexis. In this bulletin, we look at new waste enforcement regulations, the Environment Agency's latest report on water quality, and the latest Supreme Court environmental decision. Draft regulations have been laid before Parliament that allow the Environment Agency to serve a notice on the occupier of land or landowner, requiring them to remove waste that is being illegally stored on land, irrespective of whether or not the waste was illegally deposited in the first place. That means that landowners may find themselves financially at risk for the removal of waste legally brought onto their land, for example, by way of a legitimate business. It will be a criminal offence to fail to comply with such a notice. On appeal, a court must quash the requirements imposed by the notice if it is satisfied that the appellant did not keep or dispose of, or knowingly cause or knowingly permit the keeping or disposal of the waste, or alternatively, if there's a material defect in the notice. However, these regulations are fairly prosecution friendly. For example, the requirement of notice could easily be satisfied by a letter from the Environment Agency to the landowner, alerting that landowner to the existence of the waste prior to the service of a notice. Waste crime has been identified by the government as one of the most urgent problems in the environmental sector. The risk that landowners may find themselves financially at risk may encourage the development of greater scrutiny of the financial circumstances of their tenants and enhanced financial provision to guard against the possibility of being lumped with an abandoned waste site. On the 19th of February 2018, the Environment Agency published a report entitled The State of the Environment, Water Quality. The report states that there are far too many serious pollution incidents to water, 317 in 2016. In the foreword, the Environment Agency Chair Emma Howard-Boyd writes that the public and businesses must do more to keep plastics, fats and household chemicals out of our drains. In fact, the government is consulting as we record on fixed penalty notices for householders. And the foreword also states that water companies must continue reducing pollution incidents from sewer systems and sewage treatment works. She also emphasises that the size of fines imposed by criminal courts for more serious offending need to be proportionate to turnover and consistently applied by the courts. It's possible that the Chair's words betray a misunderstanding of the sentencing process in a criminal court. Fines must be proportionate to the objectives of punishment, deterrence, and the removal of gain through the commission of the offence, as well as the means of an offender, which doesn't simply equate to turnover. Although turnover is an important starting point for sentencing, there are other crucial elements that a court must consider when determining what the appropriate financial penalty should be, such as the steps that have been taken by any organisation to remedy the harm caused, the extent to which an organisation has recognised the impact of any particular criminal offence at a senior level and then acted on that recognition, and also the record of an offender. The report also identifies future pressures on water quality, including population pressure, climate change, emerging chemicals, plastic pollution, nanoparticles and fracking. But worryingly, the only mitigating action suggested in this section of the report is for the public and business to minimise the use of single-use plastics. Despite the publication of the 25-year environmental plan, as we identified in last month's newscast, the absence of proposals may reflect a lack of policy consensus as to the best way to tackle pollution problems going forwards. Action is plainly needed. In 2016, 86% of river water bodies had not reached good ecological status. On the 14th of February 2018, the Supreme Court handed down judgment in Mott against the Environment Agency. The respondent, Mr. Nigel Mott, represented by Stephen Hockman QC and Mark Beard of Six Pump Court, was a fisherman who held a leasehold interest in a fishery on the Severn estuary. The fishery was a poacher-rank, a traditional fishing technique involving the use of conical baskets to trap adult salmon as they return to a river from the open sea to spawn. Catching salmon using this method had been Mr. Mott's full-time occupation since 1979, requiring a licence granted annually by the agency. From 2012, the agency imposed a condition on his licence, limiting his annual catch very substantially. It judged the condition necessary to protect salmon stocks in the River Wye, a special area of conservation designated under the Habitats Directive. Although the catch conditions limited Mr. Mott's catch by 95%, the agency paid him no compensation. Mr. Mott sought judicial review of the agency's decisions to impose the conditions, claiming that the conditions made his fishery wholly uneconomic to operate, and he was successful in the Administrative Court and the Court of Appeal. The case before the Supreme Court was limited to consideration of his right to property, set out in Article 1, Protocol 1 of the European Convention on Human Rights. The issues arising in the appeal were whether the conditions imposed by the agency amounted to control or de facto expropriation under A1P1. If the former, whether the fair balance required compensation to be paid, and if the latter, whether exceptional circumstances justified the absence of compensation. The Supreme Court unanimously dismissed the agency's appeal. It held that the European Court of Human Rights case law showed that the distinction between expropriation and control was neither clear-cut nor crucial to the instant case. The need to attach special importance to the protection of the environment did not detract from the need to draw a fair balance between public and private interests, or from the potential relevance of compensation. The fact that the conditions imposed by the agency were closer to deprivation than mere control was clearly relevant to the fair balance. The agency gave no consideration to the particular impact on Mr. Mott's livelihood, which was severe, and it was doubtful whether the leasehold interest retained any value. This was an exceptional case on the facts, because of the severity and the disproportionate impact on Mr. Mott, but it is interesting nonetheless. It should be borne in mind that national authorities have a wide margin of discretion when imposing environmental controls, and A1P1 gives no general expectation of compensation for adverse effects. Furthermore, where the authorities have given proper consideration to the issues of fair balance, the court should give due weight to their assessment. Thank you for tuning in for this Environmental Law News Bulletin. For more information on any of these stories, please contact Six Pump Court or my colleagues at LexisNexis. We'll be back in March with a look at some of the month's key legal updates.